Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to the court will draw near to give their attendance, and they shall be heard.
Good morning. Please be seated. This morning, we do have a candidate for admission to the New York State Bar. So before we start, we're going to have him sworn in. David James Panzarella, could you come forward, please? And Dylan Flynn, the clerk of the court, will administer the oath. Ms. Dylan Flynn, has this candidate been certified to the court for admission by the appropriate committee on character and fitness as possessing the character and fitness required by an attorney and counselor at law?
Yes, Your Honor, yes.
Please administer the oath of office.
I do solemnly swear
I do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of New York,
and the Constitution of the State of New York,
and that I will faithfully discharge the duties
and I will faithfully discharge the duties
of an attorney and counselor at law
of an attorney and counselor at law
according to the best of my ability.
according to the best of my ability.
Congratulations.
Congratulations. Now, I suppose you want to stay and listen to all the arguments for the rest of the morning. Is that correct? Congratulations. Have a good day. First case for oral argument this morning, People versus Jack Simpson. And it's remote. Both parties are remote. Morning. Good morning.
Good morning.
Good morning.
You all set, Ms. White? Okay, go
I
ahead.
Good morning. May it please the court, Melissa Swartz on behalf of the appellant Jack Simpson. Unless the court has any specific questions for me, I'm going to rely on the briefs that were filed in this matter.
Thank you. Mr. Sarando?
Yes, Your Honor. John Sarando for the respondent. The only thing I'd like to say, Your Honor, briefly is that the defendant seeking a drastic exceptional remedy, which is not justified by the record herein. And I think we've laid out in our brief the cases that reflect that the grand juror in this case was competent to be fair and impartial, and we would ask that the judge.
Thank you very much.
Thank you.
The next case for our argument is 679, People versus Amber Roach.
May it please the court, Peter DiGiorgio for the appellant. I'm going to primarily focus on point 1 and 2 and then comment briefly on point 5. With respect to the issue on the failure to charge the jury that Patricia Nethaway was an accomplice as a matter of law and her testimony needed some level of cooperation, I believe the people, by not bringing it up in their brief, has conceded that she was an accomplice, but just briefly, she was a co-defendant. She pled guilty to
First of all,
attempted...
is this even preserved?
Yeah, that's going to be the issue. With respect to preservation, number one, that hurdle. And the second is, would a charge have made a difference in that there was sufficient cooperation within the record? With regard to preservation...
That was going to be my next question.
I try to anticipate what the issues are going to be in the hurdles. With respect to preservation, first of all, People v. Sage, the case I cited in my brief, says that there's a duty to charge even without a request. The question becomes, once the trial court didn't charge, I think it's incumbent upon defense counsel to make some application before the jury is discharged to request it or to object to it. This court has looked at the cooperation issue in the interest of justice on many cases, but the context of this case is different, and I think the court needs to look at it a little more closely than some of the other cases. The jury never got to consider whether Patricia Nethaway's testimony was corroborated. Most of the cases, or a large majority of the cases that this court deals with, The jury has looked at it and has found corroboration, and this court's simply looking at the record and making a determination. We skipped the whole process of whether these corroborating witnesses were credible because the jury was never told that. I submit to you that there's not overwhelming proof of guilt in this case. You pull out Patricia Nethaway's testimony from this case and substitute Amber Roche as the person who testified, and it could have been a totally different result.
We'll look at that really closely.
Okay. So I asked the court just briefly that with respect to the people's claim that there was corroborating evidence, the fact that Patricia Nethaway's testimony was consistent with what had happened that night, and it places Amber Roche's testimony that she was at the scene and she was on the floor. I cite the case in my brief that People v. Marmelstein, that present at the scene is not enough. And even the defendant's inculpatory statements where she's saying, geez, I'm an accomplice, I was there, and Earl Desmartu's testimony, I think aren't sufficient corroboration even if we looked at it. So I would ask that, and if this court doesn't reach this issue because it wasn't preserved, I would also ask that you look at the issue in the context of ineffective assistance of counsel.
We'll do so.
Thank you. With regard to point 2, a law school professor once said when you have a very difficult, complex legal issue, start out with an example. So that's what I'm going to do here. If I got angry at Mr. Johnson's today, and I said, give me your brief, and I light his brief on fire, and this building catches on fire, and I do nothing about it, I would submit that I may have intent to damage his personal property, but I don't have the intent to damage the building. How do we draw that distinction? Because I would anticipate the next question is going to be, well, don't you intend the natural and probable consequences of your acts? And if I lit Mr. Johnson's brief on fire because I was angry with him with the way he responded to my brief, and I did that, it could flow that...
Watch out, Mr. Johnson.
it could flow that this building could burn down. The difference between the arson statute is there has to be some proof of an intent to damage the building. Now,
Well, wasn't the vicinity of the scooter to the building so close that that could be inferred here that there was intent?
yeah, but where do we draw the line? There was anger. One of these two women lit, I think a fair reading of the evidence is one of these two women lit that book bag on the scooter. They were angry because of the conflict that occurred in the
We
bar.
understand all that.
Okay.
But
So I would argue, Justice Smith, that whether it's something is attached or affixed to the building or an accelerant is used. So in other words, if I took Mr. Johnson's brief, I poured gasoline on it, and I wanted a bigger flame, then that could be intent to damage the building. This is clearly, I think the evidence shows, a reckless arson. There was starting a fire, there was an intent to start a fire, and the building burned down. I think the fact that it's a personal property within the confines of the building.
I think we have that argument.
Okay. Unless the court has questions on point 1 and 2, I will move on to my final point, which is the autopsy photos. Again, there's not overwhelming evidence of guilt in this case, I would submit. The defense counsel stipulated or agreed to stipulate as to cause of death, to say that we'll put the autopsy report in, we'll stipulate that it was asphyxiation. There was no need to bring in the autopsy photos, and specifically there were a couple that were very prejudicial. One had the victims who died of asphyxiation, his tongue, that showed his tongue out of his body, and it was black and charred. What would be and the people never explained this when it was preserved and it was objected to at trial. What would be the purpose of putting that evidence in if it wasn't to inflame the jury? And I would ask the court to look at that issue in the context of there was no relevance because the people can prove the case any way they want. But once the defendant says, we'll stipulate as to cause of death, and you could put in this other non-photographic evidence, what was the purpose of bringing in those photos of his windpipe, of his tongue?
We'll look at that.
I understand. Unless the court has other questions, I'll conclude with that.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Michael Johnson for Herkimer County District Attorney's Office.
I just want to touch briefly on that last point. I don't believe there was abuse of discretion by the trial court. I believe the people have a duty to prove each and every element. That includes the death in this case. Those photos were used to corroborate Dr. Sikorica's testimony as to the autopsy he performed. I believe they were limited too. There were a lot more pictures, put it that way, that weren't brought in to corroborate that testimony. I'll move to point one as to the corroboration charge. As the defendant concedes in his brief and here today, the issue is unpreserved, and this court should decline to review that case. I would point to the fact that the defendant was represented by two seasoned attorneys in this case. They did not request an instruction, and they did not object to the lack of the instruction. And there was overwhelming evidence of guilt here. Now, Mr. DiGiorgio mentioned that we kind of glossed over the fact of whether Ms. Nethaway was an accomplice. I just want to address that by saying either she's an accomplice in fact or she's an accomplice at law. For my purposes, I don't think it matters. I think the issue is whether there was overwhelming evidence of guilt, whether the lack of the charge was harmless error. And I do believe it was harmless error. In fact, there were 11 fact witnesses that testified to what happened before.
Well, everything is corroborated anyways, correct?
There is corroboration. Her testimony was corroborated, both before, during, and after, right?
I think we have that.
Okay, and then in regard to the sufficiency argument, I can understand Mr. DiGiorgio's argument that there was no intent to burn down the building. And yet he cites no case where he can point to a fire being set in a building that is inhabited and it was not ruled intentional. In fact, we cite 3 cases, at least 3 cases, could have cited many, many more for that proposition where a fire was started in an inhabited building and that fire spread, people were injured. That is the definition of arson. I think the cases bring that out.
I think we have that.
Okay. And I want to touch on the multiplicitous argument in point 4. I think all 7 counts require proof of a different victim in that. I think that's pretty clear. That's what the law is. And with that, if there are no other questions, I will rest on my brief.
Thank you. 680, People versus Rainey. Good morning. Can you unmute yourself, please?
Hear me?
Perfect. Thank you. Go ahead.
Morning, and may it please the court. Nicholas DeFonso, hearing for Jamar Rainey. Today, I'd like to focus my comments on the suppression point and briefly on the harsh and excessive. The identifications in this case should have been suppressed as the identification procedures were unduly suggestive. Officer Cyrex improvised instruction for Ms. Anderson to, in essence, make her best guess, transform the photo array from a test of recognition to a test of resemblance. This undermined the basic purpose of the procedure.
Well, Counsel, he never told her who to select or suggested who in that array she should select, did he?
No, he did not. He did not, like, for instance, circle Mr. Rainey's picture, but he did indicate to her that she should make a selection, in essence, to select the person who looked most like the person in her memory. When she said that she didn't really recognize anyone, which
And
changes, I think. Oh, go ahead.
Wasn't that because the photos were in black and white and she was having a hard time, making it out, and things changed though, didn't they, when the photos were then in color? And she made a pretty almost immediate decision, didn't she?
He did mention that the problem was with the complexion in the original black and white photo array. However, as for the second photo array, it's impossible to tell whether she's, her memory, whether her selection was from her memory of the event or from her memory of the initial photo array. where Officer Sirek then, pressured her to make a selection, not the right selection that people would, acknowledge in their brief, which is the problem with his instruction. Pressuring the witness to make a selection, any selection,
I
is
think
not
we have that argument. We'll look at
okay.
that.
In addition to that, in this court's totality of the circumstances review, I would invite the court to look at the actual photo arrays and see if they can't select Mr. Rainey's picture from, by process of elimination, given the constraints that Ms. Anderson said the gunman had acne and that she could only see a portion of his face. And so part of our argument is that the procedure was also unduly suggestive because of the composition of the photo array. The problems, of course, of the first array extend to the second. In colored, the composition problems extend to the second color photo array. And also, I don't see the logic behind the 2 months passage of time ameliorating any undue suggestion in the first photo array. I don't see, the example I used in the brief was an unambiguously suggestive photo array procedure where, for instance, the defendant's picture is circled in red ink. I don't think that 2 months later that bell is unrung.
Okay, I think we have your argument with regard to the photo array.
Photo array. Okay. The argument continues regarding that there's no record support for the court's determination that there was an independent source, which is important if you agree with me. Then we move on to the independent source prong of the suppression decision, and I would invite the court to take a look at those factors. And our argument is that most of them weigh in favor of the defense, and that if they were weighed correctly, that they should have resulted in the suppression of the identifications in this case. Moving on to the harsh and excessive argument, I would just note that this is another case where the trial penalty is quite high. He was offered a plea that would have resulted in a 5-year term and eventually sentenced to 12 years. That's pretty high. And the judge noted that Ms. Anderson didn't want to testify. However, there was nothing particularly traumatic concerning her testimony in this case, as opposed to, for instance, other cases. And so I would invite the court to, or I would ask the court to take a look at that, particularly in light of the fact that this end result sentence was more than twice as the amount of the plea offered.
Thank you.
May it please the court, Michael Hillary for the people. I'll just touch on the identification issue briefly. The suggestion or the claimed improperly suggestive comment by the detective here was not hastily made. That came after an initial vague identification, and then maybe 4 and 5, and then it would help if these were in color. I can't tell based on the skin tone, based on the black and white. I wonder what the detective was supposed to do in a situation like that. Leave it alone, or simply say, exactly what he did. Please pick the person that you believe you saw that night, which she did. She then, 2 months later, was shown a color photo array at the district attorney's office, and unequivocally she picked the defendant out of that array. So I believe there was nothing here to suggest that there was any taint, no suggestiveness by the detective. It was fairly done. It was appropriately and logically done on his part.
And what about the independent basis in any event?
Well, the independent basis, I suppose, Judge, finds support in the record by virtue of the length of the encounter. There were several minutes. I believe it was, I think she testified to a 5-minute long encounter. Well lit. I mean, she was close enough, in her words, to be kissing this defendant in this car. There was a dome light on in the car. There was a light by the building about 100 feet away, light across the street. So I think that given the time and the lighting conditions there, that the court can feel confident that she had ample opportunity to see this man and remember him.
Now, counsel makes an argument that the 12-year term was far in excess of the 5 years that he might have had it had he pled. Almost like a penalty of some kind. Can you speak to that?
Well, Judge, I think It's a matter of the court's discretion, having put the people to the proof and required the testimony of basically this woman having to relive the trauma. As the court knows from the record, she was a very reluctant witness. She didn't want to talk to the people. She did, of course, and she testified. But she had to relive that encounter, and then the court heard, of course, the details of this encounter, a gun to her, 2 individuals involved, a drawn-out 5-minute encounter. So given the violent nature of the crime and all those facts and circumstances, I think the court was within its discretion to sentence the defendant as it did. Thank you.
Thank you. 681 in the matter of Nomi C. Morning, just 1 minute. Oh, good morning to both of you.
Morning, Your Honor.
Go ahead.
Good morning, and may it please the court, on behalf of the department, Benjamin Mannion. I won't belabor the points that were made in the department's brief. I would just like to touch briefly upon the preservation issue. Your Honors, in reviewing appellant's brief, appellant seems to advance what appears to be a sufficiency of the evidence argument rather than a weight of the evidence argument. I would ask the court, upon reviewing appellant's brief again, to view that argument in that light, and as such, the department contends that appellant has not preserved that argument on appeal, as there was no motion to dismiss the department's case due to insufficient evidence at trial. Beyond that, I would just also like to briefly touch on appellant's contention that there was a language barrier in this case, or that an interpreter should have been used as part of Dr. Nathanson's evaluation. I would note that the appointment order for Dr. Nathanson was not included as part of the record. However, there is reference to it by the trial court judge during the proceedings. This is an order that would have been either agreed to or stipulated to as part of the court proceedings, and the lack of any evidence whatsoever in the record that shows that there was a disagreement as to Dr. Nathanson being appointed clearly demonstrates at trial that appellant was more than willing to allow this to be weighed by the trial court judge rather than make any kind of argument as to language barriers or anything whatsoever. This is a matter of comfort in a language versus notice and necessity. And as appellant demonstrated, particularly when she was observed by Dr. Nathanson, directing the child over the course of an hour in concepts such as opening and closing a door, asking for a cupcake, describing a cupcake, all in English, in addition to the fact that Dr. Nathanson repeatedly asked